Well, hello everybody. Thank you for watching our video. Today what we're going to do is we're going to talk about Medi-Cal planning, specifically in California. We do practice law in California, so that's why it's specifically designated for California, but I will interject as to what's going on in some other states here and there. And in fact, to give you an overview of what we actually do, here's a beautiful chart that you can see that everything starts with estate planning. Everything must be in writing. And if you watch some of our other videos, you'll get a little idea of what the estate planning actually entails. But you can see that everything spins off of estate planning, specifically the elder law section. Medi-Cal is the only public benefit for long-term care, and it is what we have to apply for if we want that benefit to help pay for that long-term care. So it's a major part of our practice, and I'm really kind of proud to talk about it today. It's been in the practice for over 30 years. We've been doing Medi-Cal planning within the California structure. We have a great team behind us as to who can help us, and all the other bullets that are under that elder law section is part of what our team can do, on your behalf. So with that in mind, just what is Medi-Cal? Medi-Cal is the long-term care program in California, but it is a federal program initiated by the federal government, and it's called Medicaid. I'm sure most of you from out of state think of it as Medicaid. In California, we typically call it Medi-Cal. Now, because it is a federal program that was started back in 1965 under the Lyndon Johnson administration, the federal program of Medi-Cal is delegated to all the states in the nation, where each state can implement the bureaucracy of their own long-term care program. California just typically calls it Medi-Cal. So with that in mind, California now is still running under federal Medicaid rules that were established in the 1980s. So why is that significant? Well, the Medicaid rules at the federal level change every once in a while, and specifically what they're doing is changing the rules to make it a little more difficult to get qualified for Medicaid because of the baby boomers that are now coming up through the system, getting to that age where they're going to be applying for long-term care assistance. However, California is going in the opposite direction. Now, how it really works is each state can adopt up to the restrictions of the federal government, but they cannot be more restrictive. California has chosen, however, to be less restrictive. So I guess the moral of the story here is if you want long-term care and want to easily apply for it, move to California. So with that in mind, again, we are running under 1980 federal Medicaid rules that allow us to shelter all our assets that we have prior to immediately going in and qualifying for the Medi-Cal benefit to pay for the long-term care. In 49 other states, to put it easily, there is no movement of monies, no sheltering of monies or property 5 years prior going into the nursing home, which makes it very difficult, if not impossible, to actually pre-plan for Medi-Cal, or I should say Medicaid, in all the 49 other states. But in California, we're allowed to pre-plan. We're allowed to arrange our assets to have them sheltered and then turn around and get qualified for the Medi-Cal benefit to pay for everything. Now, one of the newest implementations that's going on in California right now is we have adopted new rules starting July 1st, 2022. These rules, rather than making it more restrictive in getting qualified for the Medi-Cal benefit, actually make it less restrictive. So the new rules of July 1st allow the ill spouse to keep more money than they ever used to, and also allows the well spouse to keep more money than they ever will or were able to be done. So what I'm getting at this point in time is we're going to go through those new current rules as of July 1st, 2022, give you an idea of exactly what you as the well spouse or ill spouse can keep and still get qualified for Medi-Cal. Now, we also have rumors coming through the system that in 2024 there's going to be a new implementation of rules in California. And again, they're going to make it less restrictive to get qualified. Now, the rumors, and this is only rumors, is that by 2024 there's going to be no asset limit in qualifying for Medi-Cal in California. Essentially, you can have millions of dollars of value in property and in investments and still get on Medi-Cal to pay for long-term care. Now, the rumor also is that the reason they're doing this, and the insurance industry is who I've been talking to, is that California wants a universal health care system, and they want to force everybody to pay for long-term care. That is why in 2024 they're not going to care about what assets you have, because everybody apparently is going to have the long-term care insurance. Well, that is still a rumor. We don't know if that's really going to happen, but that is what I've been hearing through the grapevine. So with that in mind, I'd like to give you a little Medi-Cal overview and the purpose behind actually getting it. And when you do get the Medi-Cal benefit, why are we doing everything that we're going to do in order to rearrange your assets? Well, bottom line is that the rules have a limit on what you're allowed to have at this particular point in time. So what we want to do is protect your assets from Medi-Cal spend down. In other words, I don't want you to go out and spend the money on a long-term care facility when in fact legally you can save everything you have and shelter it and still get the Medi-Cal benefits. So what we're going to do is go through the spend down process, how to protect your assets. We also want to make sure we're avoiding any kind of recovery claim against your home or any other real estate that you may have. Now that rule has become very simplified lately. Bottom line is, if you have a revocable living trust, you're avoiding probate, your house is titled in your revocable living trust, the state of California under Medi-Cal will not come after that home as a recovery asset to pay them back for money spent on your care. So think about it. The importance of having a revocable living trust, not only to avoid probate for your family and keep your family out of court, but also to now make sure that if you go into long-term care, the state's not going to come after your house. And it starts with a revocable living trust. Now, there are certain legal ways to turn countable assets into protected assets. This is in a sense what I've already been talking about with the spend down. We do not want, or I should say, we want to change countable assets that's going to deprive you of getting the benefit and turn them into protected assets so that we can actually shelter everything. Now, what I want to mention is there are special powers that go in your revocable living trust that allows us to protect your assets. And what I mean by special powers is that the typical scenario of how this gets started is I get a phone call from a son or a daughter or some other family members about mom and dad. Mom and dad are heading towards long-term care. Their concern is, what do we do? How do we protect the assets? How do we get some coverage for them? How do we protect them when it comes to long-term care concerns? Well, in doing so, we are going to be moving and sheltering assets. And once you start moving and sheltering assets on behalf of parents, the children have to have their power of attorneys. They have to have certain language in the trust documents that allow this to happen. Nobody wants to be accused of elder financial abuse or any of the other issues that could crop up. And so the importance of having a writing where these powers have been delegated from the parents to the children in order to act on their behalf to protect the estate is very important. So one of the first things we do is ask, do you have a revocable living trust in place? Do you have a valid financial power of attorney with these special powers that will allow the family to protect the assets if a parent has to go into long-term care? Now, when it comes to Medi-Cal, a good overview is to think of preliminary matters that may be accomplish prior to coming in and seeing me? This is a typical question that I get asked all the time. What can I do ahead of time to protect my parents, so to speak, from losing everything that they've worked for on a long-term care facilities? So what I decided to do was show you this slide here and give you a little bit of advice on some of the things you can do without necessarily coming into the office. So first thing, consolidate your assets. It's very difficult to deal with parents' assets that are spread all over town in maybe 12 different institutions, 12 different banks, brokerage houses, and things of that nature. So in my mind, it's nice to have a brokerage account where you keep your stocks, bonds, mutual funds, your investments. It's okay to have a savings account for your cash money and a checking account. Outside of that, there's really no reason as we age and get into our late 80s, early 90s to have assets spread all over town in various different institutions. If the assets are spread all over town in different institutions, it just takes that much longer to consolidate them anyway into, one workable account, especially in order to help shelter and get them moved. A little bit more about that as we go along. The other big issue has to do with addressing rental property. Rental property is actually one of the most difficult assets to contend with when it comes to Medi-Cal planning and sheltering of assets. So right away, one of the first questions after I ask if you have a revocable living trust is, do you have rental properties? Protecting the house that the parents live in or the ill person lives in is very easy, but rental properties are a little problematic, and we'll get into that a little bit later on another slide. So the next step is, does everybody have a revocable living trust? Do the parents, in a sense, have that revocable living trust with those special powers that we've already talked about? If, in fact, you do not have a revocable living trust set up and the parents or the ill spouse actually does need one, those are what we're going to assess and we're going to provide as part of the Medi-Cal planning. But we'll also look over the existing revocable living trust, and if there's any updating that needs to be done, we'll make sure that they get done, especially making sure those special powers that I alluded to earlier are actually in the document. So with that, we're also going to be looking at the powers of attorney. We do want to make sure that there are valid healthcare and financial power of attorneys in order, especially the financial power of attorneys. Again, that special power or special language regarding Medi-Cal must be not only in the revocable living trust, but also in your financial or general power of attorney, sometimes they're called. Now, a couple more bullets here on this slide, which is, believe it or not, rather important, but it's something we always overlook. And the first one, number 5 up there, is does your parent or the ill spouse, have a valid photo ID? It is so common that folks will come in as they've aged, they've let their driver's license lapse. And then they've never gone out and gotten a valid California ID card. Well, when it comes down to moving assets and signing new documents, through a notary and making sure everything's in place in terms of getting everything organized to get qualified for that Medi-Cal benefit, I am going to have a valid photo ID. So I guess my soapbox here is, children, if you're thinking about what to do with your parents in terms of their aging and getting on long-term care, please get them out to get a valid photo ID, because it will go a long ways in getting everything done and run smoothly when you do have that. If you don't have a valid photo ID, you can't even do a notary. So please get a photo ID that's actually valid. Another big common issue is the checking account. Checking accounts, usually I always advise my clients not to put the checking account into the name of the trust. And the reason for that is, if it is a trust asset, you cannot put that trusted son or daughter on that checking account in order to write checks on your behalf if you can't. So we always keep the checking account out of the trust so that you can add that trusted son, child, daughter, whoever that you have as a confidant in your family, so that once they're on the checking account, they're in a position to write checks, which also is a process of sheltering the assets and making sure we get under the numbers that we need to in order to qualify for the Medi-Cal. All right, now some of the problems affecting Medi-Cal eligibility I decided to go over with you real quickly here. These are the stumbling blocks or the harder issues that we usually have to face. Now, what I'm getting at, first of all, is whoever's applying for the Medi-Cal, if that's the ill spouse or the ill parent, we need to know their gross worth. Nobody cares about the net. Medi-Cal does not care what kind of mortgage you have on your house. It's all about gross estate value. So the first thing we do is we determine what is that gross estate value of the applicant. And if the applicant has a spouse, we need to know their gross worth too. You know, in California, it's a community property state, so it's everybody's money, husband and wife, and that's how we usually handle it in a husband and wife situation. But again, gross estate value, not net. And then the next big issue has to do with, you know, that rental property. Okay, when it comes to rental properties, it is an asset that will count against you. And the first thing we worry about is rental income. I do not want rental income reported to mom and or dad, whoever's applying or not applying, who's the well spouse when it comes to Medi-Cal. That income will just get chewed up and go out to the share of cost of the nursing home, and it just simply means that Medi-Cal will pay less. So why give the rental income to the nursing home? And so what we want to do is get past that issue. We don't want rental income reported to mom and or dad. Now, the other big issue is that they cannot have a rental property sitting out there unless that rental value falls under the asset limit that they're allowed to keep, which we'll talk about in a moment. So typically what happens is we're going to have to shelter that rental property. That rental property, in getting sheltered, will also shift the income over to either a trust or the family members, not to the parents or the one applying for the Medi-Cal. And we have to get through all of the hoops that is involved in getting that accomplished. Specifically, really quickly, it means probably drafting a number of deeds based on the assessed value of the rental property, not the fair market value, the assessed value. Now, assessed values on your tax statement. So look on your tax statement what the county's charging you in terms of the value of the rental property, and we take that number, divide it by 10,000, and that tells us how many deeds we have to create in order to move it out, one deed per day until it's done. Now, I'll go over that in more detail when you come in and talk to us, but the point being is if you don't have rental property, forget about everything I just said. We don't have to worry about it. Now, what I mean by bullet number 3 down there, the probate rule. Whenever I go into probate, I have to notify Medi-Cal within California that a probate has been filed so that they can go into the records to see if there's any recovery claim against the estate that's being probated. So once again, do a revocable living trust, stay out of probate, and if we have a revocable living trust as an estate plan and we're not ending up in probate, then there is no rule to sit there and turn around and tell Medi-Cal what we're up to. Okay? So again, the revocable living trust keeps us out of court, avoids the probate, and we now don't have to tell Medi-Cal that the estate's in a probate situation. Now, another big issue, number 4, is the cost in cashing out annuities. Now, I mention this simply because there's a lot of protection in the financial planning world to not sell annuities to elderly people. I think there is an age limit, you know, when it comes to where the financial planners cannot do it. But some of these annuities that I come across outlast that age, and they can go into, you know, the late 80s, late 90s of the parent or spouse that needs to qualify for the annuity. And guess what? If we have to cash it out if we're going to shelter it, and cashing it out means surrender charges and penalties. So if there's anything as a child you can do is tell your parents not to invest in annuities as they get up into the late 80s and early 90s, so that we don't have to worry about surrender charges, etc., and the complications of closing out annuities. Now, the last bullet on this problem section has to do with life insurance. It's really not a problem so much, but it takes time. You know, we have to contact the life insurance companies, and if you have whole or universal life, it has a cash value, and we need to get rid of that cash value. The actual rule is you can have a cash value of $1,500 or less, and therefore the life insurance doesn't count. However, $1,500 or less is a very, very small cash value, and I quite honestly never see that. I always see cash values in the tens of thousands or even more sometimes. Well, what happens is that is a countable asset, that cash value, and so we're going to need to ascertain exactly what the cash value is, and we're going to have to do some planning to get rid of it. There's some strategies for doing that. Sometimes it could be as simple as changing ownership of the life insurance policy. Sometimes we just cash it out. Sometimes we cash it out down to less than $1,500. And then the drawback to all of this is you lose your death benefit if we're cashing out life insurance. So we always have to address the life insurance issues. And again, it's not so much a problem, it just takes time, and time means money when it comes to qualifying for Medi-Cal, especially if someone's already in the facility. So with that, in California, we actually have two approaches. And when I sit down with you to go over what is the best Medi-Cal approach, this is in a sense what we're discussing. So the first approach really pops up in three instances. If the person has to actually go into long-term care, into a long-term care facility, or if the applicant wants to stay at home and still tap into Medi-Cal to pay for that in-home support services. And that's under IHSS in California, which in a sense means in-home support services. The third choice that we have is board and care under the assisted waiver program. So bottom line is, if we're going to go through HCBS waiver and or long-term care program, these are the three goals that we want to ascertain. Is the applicant going to stay at home? Is the applicant going to go into board and care? Or are they going directly into a nursing home? Now the result is, under these new rules starting July 1st, 2022 that I mentioned earlier, the applicant can now keep up to $130,000 and still get qualified. Before, the rule was they could not have over $2,000. And now, if you have a well spouse, that well spouse can keep over $137,400. So this means if you're a husband and wife with one ill spouse, one going into a nursing home or long-term care type plan, you can actually keep as husband and wife $267,400 plus whatever's exempt anyway. And whatever is exempt anyway is your house that you actually live in, your principal residence. And remember, it's going to avoid a recovery claim from the state of California because we're going to have it in a revocable living trust, avoiding probate, and California will not come after a home if the home has avoided probate. Now, the other big issue that I come across that is exempt is your IRAs. All your pension retirement plans and IRAs do not count in California as an asset when it comes to qualifying for Medi-Cal. So bottom line is, we simply don't worry about them. We keep them as they are and don't touch them, and they're there to stay. Now, the other approach is what we usually call regular Medi-Cal. Now, what is that? Well, regular Medi-Cal means that somebody wants to pre-plan. They don't necessarily need the Medi-Cal right now. They're not actually entering into a long-term care facility or staying at home under IHSS. So this is where somebody wants to have it pre-planned. They want it in the can, so to speak, so that when things start happening and long-term care is creeping up where it's actually going to be needed, you already have it in place. Now, you will also use this when you want to have, maybe Medi-Cal cover all your co-pays when it comes to pills and things of that nature. So that's the regular Medi-Cal planning, and in a sense it's pre-planning. So What's the result if we qualify under this approach? The applicant can keep up to $130,000. These are those new July 1st rules. And the well spouse can keep up to $65,000. You'll notice it's a little less than if you go into the long-term care facility on that issue. But the husband and wife can keep a total of $195,000, including everything I already talked about that's exempt. You know, IRAs, pension, retirement plans, and the house, of course. Now, there's also a subtle little rule here too, that if you actually have minor children and you're applying for this type of regular Medi-Cal, each child can be credited with $65,000 up to 10 children. Now, you may be wondering, now, why would that ever kick in? Why would I need to worry about that? You know, my parents are 80, 90 years of age. Of course, they don't have minor children. Well, we do a lot of planning for Medi-Cal when folks come down with specifically MS. And it's a sad situation to see, you know, literally a 45-year-old lady, you know, who has MS, can't take care of her minor children anymore, and yet they're there, they have expenses. And so now the state of California gives us, you know, a little bit of a break if that's the type of situation that we're working with. Okay, so what do you do if, in fact, the thresholds that we talked about on the previous slide are not met, in the sense that your parents or the ill spouse has more assets than what those thresholds were? So that's why I like to show this slide right here. There's really two approaches to this situation. It has to do with whether or not we're sheltering just money, funds, or whether we're worried about the house. So remember, we've been talking about the house being left alone in a revocable living trust. Again, the state of California is not going to have a recovery claim against the parent's home, you know, if you're avoiding probate, and the best way to do that is through a revocable living trust. But why would you use a house trust? Well, it kind of boils down to the facts and circumstances that we're going to have to deal with when you come in and see me. So what I'm basically getting at is this. If you want to avoid a recovery claim on the home, we can leave the home alone. But a home just sitting there empty is going to cost a lot of money. You know, there's always expenses with the home, from property taxes to maintenance, upkeep, etc. And you cannot rent it out with it being in your parents' name, because they have to report the income, and that's going to ruin the Medi-Cal. So sometimes we use a house trust to kind of avoid these situations, especially when it comes down to the children not knowing exactly what to do with the house. You know, maybe you change your mind, you know, later on down the road, and you don't want to be stuck in a program that's going to cause a problem. Well, here's what I'm getting at. If you leave it in the revocable living trust, you're fine. You cannot rent it out, but it will sit there, and the state of California is not going to come after it to recover against it. You can sell that home somewhere on down the line or in the beginning of the Medi-Cal planning. But once it's sold, we simply gift it and move the funds out like we're going to talk about in a moment. The other big benefit for keeping the home is you get a stepped-up tax basis upon death, and that might be very, very important. The basis in the property is whatever the parents actually paid for it, and it appreciates in value. Well, one of the perks that we get for living in the United States of America is if you pass away and leave behind capital gain property, that would be real estate or stocks, bonds, mutual funds, all that capital gain property will achieve a stepped-up tax basis on the death of the owner, the parent here in this case, so that the children can turn around and sell the assets without a capital gains tax hit. That's very important, especially if you have a real low basis on that house. As an example, I have a lot of clients who maybe bought their home in the Los Angeles area for $30,000 back in the 1960s. Well, now it's worth over $3 million or sometimes $6 million, depending on where it's at. So you have a huge capital gain built up into that household, and moving it out to another owner or into another trust could cause a big problem and a big tax hit, and we don't want that to happen. So one of the first things we do is discuss the value of the home, what kind of basis is in that home, and what's the best approach. So why would you use a house trust rather than just leaving the house in the revocable living trust? Well, it kind of boils down to what the family wants. The first step is that if the family wants to rent that house out without selling it, then if they move it into the house trust, the rental income's reported to the house trust and not to the parents, and it doesn't ruin the Medi-Cal. Sometimes the family doesn't know what to do with the house when we get into the middle of planning everything. So if you don't have your mind made up on what you're going to do with the home, we could put it into the house trust, and you can change your mind on what you want to do with it later on down the line without it affecting, the Medi-Cal that we've now gotten for the parent. So what I'm basically getting at is once it's in the house trust, you can either keep it there, you can rent it out, report the rental income to the trust, you could sell it, the sales proceeds goes back into the trust, not to mom and dad, and doesn't ruin their benefit. So you got a lot of, approaches when it comes to using the house trust as opposed to a revocable living trust. I think the most important aspect of the house trust, though, is your parents, once they deed the house into that house trust, they're going to retain a right to occupy that home. Now, that retention is not any, or does not have any value according to Medi-Cal, which means Medi-Cal's not going to come after a right to occupy and want to recover against it. Again, it has no value, so Medi-Cal's not going to come after it. But the significance of retaining a right to occupy is that upon the parent's death, if you still own that home in that house trust, you're also going to achieve a stepped-up tax basis because of that right to occupy retention. So you really get the best of both worlds by using the house trust in the sense of you can always change your mind on what you want to do with the home without it affecting the Medi-Cal outcome. Now, the movement of funds. This is the most common area that we get into when it comes to protecting the parent's assets. So if the parent's money, stocks, bonds, mutual funds, is above the thresholds that we talked about on the previous slide, how do you shelter that extra money? Well, in all states in the nation, 49 other states other than California, there is no movement of any funds 5 years prior to going into a nursing home. But in California, we don't care. What we're worried about is when we shelter money, we do not want it to create a period of ineligibility. That period of ineligibility is a time period that once you write a big check to somebody, that you have to wait before you're allowed to go in and qualify for the Medi-Cal. Well, we don't want to trigger that. So how we get around doing it, and this goes back to the fact that California is running under 1980 federal Medicaid rules, which allows all this to happen. So what I'm getting at is simply this. In order not to create a period of ineligibility, we are going to take the amount of money that we need to shelter, divide it by $10,000. That tells me how many days we need to move the money out at $10,000 per day clip. And once we go into Medi-Cal, or what I should say is once it's done, we go into Medi-Cal, and when we go into Medi-Cal and report what we're doing and how we want the Medi-Cal benefit, they will look back to see that we moved that extra money. But how we moved it never created a period of ineligibility, which means they're immediately eligible for the Medi-Cal benefit, despite the fact that we sheltered the funds. So maybe to give you a good little picture of what I'm actually getting at, I'm going to show you this slide right here. Now, this is a husband and wife example, and we're going to say husband is the ill spouse. So the first thing we're going to do is move the money all down into the well spouse's name. Now, remember, under certain thresholds, the ill spouse can keep $130,000 and the well spouse can keep a little bit more than that. So we're talking about $200 and some odd thousand based on that previous slide. And you now get to keep whatever's exempt, the house, the pension, retirement plans. But what if you're over that threshold? Again, what we want to do is move out the value at $10,000 per day so that we do not create a period of ineligibility. Now you'll notice on the chart we're picking a son or a daughter to move the money to. They deposit it into their account and then they move the money in one lump sum into a special needs trust. By using the son or daughter as a conduit for these funds, I can now design that special needs trust where the first beneficiary is the well spouse, in this case the wife. So that means if the husband passes away after using long-term care and the well spouse wants her money back, the special needs trust can provide the money right back to that parent. Now, if that is not the scenario, in the sense that maybe husband has passed away after receiving the Medi-Cal, now wife needs the Medi-Cal, we just gift out what she cannot have now that she's a single person, get her down to $130,000, we move it to through that trusted son or daughter, and then we move it into that existing special needs trust that we use for the first ill spouse. Now, the second spouse passes away, so the contingent beneficiary under the special needs trust is the family. Just like the old revocable living trust that the parents used to have, that is mimicked in the special needs trust. So as you can see from this slide, it's a very simple process. We'll help you get all this organized and move all the money out. We will tell Medi-Cal how we did it so that they know exactly what's going on and of course approve the benefit. Now, what if we needed a house trust? I will show this slide right here just to show what we're doing. We're going to still gift the money just like we talked about on the previous slide, $10,000 per day. When it comes to the house that the parent or spouses actually live in, that is an exempt asset in the context that I don't have to worry about a period of ineligibility being created by moving the principal residence. It will take one deed, we move it into the house trust with a right to occupy back to the person who deeded it to the house trust. Now, the ultimate beneficiary of the house trust is the family, of course, just like the old revocable living trust. So once it's in the house trust again, the family can rent it out, they can sell it, they can let it just sit there and grow weeds, they can change their mind on what they want to do with the home, and it will not affect, the eligibility or the Medi-Cal benefit that the parent is actually receiving. So with that, this is Dale Bethel, Bethel Law Corporation. I enjoy Medi-Cal planning. I've been doing it for over 30 years. We have a great team that can help us with all the ancillary issues that have to be contended with, specifically placement and brokerage firms that can help move the money through wire transfers rather than writing checks, etc. These are little side rules, or I shouldn't say rules, but side issues that we can get into once you come in and speak to us. Thank you for watching our video. Be sure to like, subscribe, and ring the bell, or watch other great videos that we may have.